It's a common misconception that LOIs aren't binding anyway, so just put whatever you want in there and then just get it signed. That's the worst approach ever.
That's Eric Hsu, founder of Clear Focus Law and one of the most sought out M&A lawyer in the searcher and SMB community. With 11 plus years of experience, he has represented buyers in over 100 plus deals worth over $200 million, and he has advised over 200 clients in various aspects of M&A transactions. And in this episode, he's going to walk us through his exact 5-step process to protect yourself from M&A frauds and scams, which includes how to do a pre-diligence on the seller and the business.
I think a lot of buyers can do a lot of their own homework up front. I mean, so much of what's available to vet sellers, to vet companies, is what they call OSINT, or open source intelligence.
How to do a deeper legal diligence.
We have a legal due diligence list. It's probably about 40, 50 items that we want from most sellers. Everything from the documents that form the company. So we want to see
deal structures that protects you.
We don't give all cash closings if we can at all avoid it. And the way we do that is we have
structuring the agreements.
People just use what's on the SIM, and believe it or not, I'd say at least 50% of the time the name on the SIM is not accurate.
Leveraging reps and warranties insurance.
Seller can sleep better at night knowing they're not going to get sued. Buyer knows there's an insurance policy to cover reps and warranties, indemnity problems that they might encounter. And
so most people don't know this, but you have been in the law enforcement for like 10 plus years. So just so that, let me look at my notes so I don't miss anything. You have been a law clerk, police officer, deputy district attorney, public defender, legal advisor, specialized and worked on internet crimes, and now an M&A lawyer. I mean, you have seen deception at like every level possible. And I feel like you're probably one of the most qualified people, to talk about this specific topic on how to, protect buyers during the M&A process. So based on everything you have seen with all the M&A deals and with your previous experience, like what is the first step when it comes to, protecting buyers from like M&A fraud or M&A scams that's been happening quite a lot?
Sure. Yeah, I think a lot of buyers can do a lot of their own homework up front. I mean, so much of what's available to vet sellers, the vet companies, is what they call OSINT, or open source intelligence. Google searches, using AI to help you understand the industry, to even ask AI, hey, what should I be looking at if I'm buying a business in this particular industry? What should I be looking at as far as competitors in this industry? What should I be looking at as far as due diligence questions that I should be asking the seller in this industry? And then just using social media, using things such as open corporates. There is, even compared to kind of just, you brought me back to my law enforcement days a little bit. Back then, oh my goodness, everything was like proprietary, accurate, and, all the law enforcement databases, which are still around, and which are much more robust now, and we use a number of those to help people do diligence on a legal aspect when we're engaged. But so much of that has been open source now. So many buyers can really do themselves a favor by just doing their homework, by combing through the internet and other open source intelligence sources just to find out what they can about the seller. Even just down to like reading their LinkedIn posts. Let's find out what this person's all about. Sometimes it raises red flags. Sometimes it's just gathering information for another piece of the process, which is building a rapport. If you kind of weed out okay, I didn't find anything weird about this seller, well, you've probably got some good information that you can use to build a rapport, build a relationship. Because Main Street businesses, Main Street, lower middle market businesses, small businesses, it's all about the rapport and the relationship if you're going to actually have a smooth deal. I've even had people do, mystery shopping. So you yourself, have your friend, have your spouse, just call up the business, pretend you're a disgruntled customer, or ask about some customer service issues. Make it a little tricky, or just see how they operate. Sometimes it's just like looking at how are they operating now, or you might find out that there's opportunities for expanding or enhancing the business after acquisition. If you call and you want a quote and they're planning on sending people out with, yellow notepads and things in writing, for example, in a home services business, that gives the opportunity to leverage technology and use such things as Service Titan or Jobber or things like that, where a lot of buyers are using these days. So you can learn more information there, and then you can also figure out what kind of an operation they run, whether they're real. Even just doing a drive-by and making sure that the business actually exists. It's very basic, but again, going back to your point about fraud, you want to make sure, and that's one of those things that if you use SBA for lending, they actually have to send someone to the location and do a site visit to make sure it actually exists before they'll lend to you. Of course, sometimes people do full cash deals, or they just buy a business with creative financing that doesn't include or involve the SBA. So they should be doing those same things themselves.
So other than, like making sure they have they own the locations or whatever. So is there anything specific, where a buyer may be looking to buy the first business or second business, where they could do some research and, you mentioned Google research and stuff. Anything specific you are looking for when they're looking at the social media or when you're doing a Google search, maybe any 2-3 things you are like common things you have seen that those are the first 3 things someone should actually look at?
Sure, you're looking for derogatory news. So anything negative about the business, about the seller, that doesn't pop up very often. We use a very robust tool that searches news outlets throughout the country, and that doesn't even pop things up, or things don't pop up there very often, but occasionally they will. And I've had more astute buyers like just do a Google search and find out, oh, the seller was convicted of fraud in federal court last year. That would show up, and that should be one of those early things that you can find and go, okay, time to move on. Another one is liens. So these are either UCC liens or tax liens. That's easy for a buyer to do really quick research on. They just need to go to the Secretary of State's website usually, or sometimes it's another agency depending on the state, and they can just plug in the seller's name and plug in the business name and see if there's any liens. It doesn't mean that you can't buy the business, but it's an early flag that there are things that you need to make sure to sort out with the seller. And if there's like a giant tax lien, that could be a problem, because that could mean that they haven't been paying their taxes. And as a buyer, you may end up being responsible for it.
We had an investor bought a business, and then the seller kind of scammed him. Somehow they were able to recoup it. But after buying the business, they went and did one Google search, and there was an entire Reddit post of people telling, about talking about this guy, like how he scammed them off, whatever, the X amount of money. So I think one Google search could save a lot of money.
Oh, yeah. I mean, another one, I was going to say, one final one I always recommend people do, and again, as a buyer, you can do this yourself, is type in the name of the business and then type in reviews. And you want to read their Yelp reviews. You want to read their, Bird's Eye, I think, is one that does home services business, or Angie's List. See what people are saying. I mean, that's going to stick with the business for a long time, even after you buy it. And that can really tell you things that the seller's not really telling you. If it's a, average 2-star business, it's going to take, it's almost like a turnaround acquisition. Then you're buying a business that's struggling, as opposed to buying something that's got a lot of positive reviews where the reviews are actually an asset.
So in response to a tweet in 2023, so you said one thing I have found is a strong direct correlation between things like horrible driving record and potential for irrational negotiations with the seller. I mean, that's an interesting insight. Like, can you tell us about that? And also, like, have you found anything similar so that, the buyers could actually look for that during the due diligence?
Sure. And that's one of those things that pops up because we do background checks on sellers. And I've had a number of deals where, it's not like 1 or 2 speeding tickets or a DUI when they're younger, but sometimes we'll do the background check and it'll be like, this person has had 8 speeding tickets in the last 2 years and a number of DUIs. It's like, that doesn't affect the way they operate their business as a business owner, but it gives us insight into how likely they are to be like I said, like you pointed out in my post, whether they're going to be a hothead, whether they're going to be rash, because the fact is business acquisition deals are like roller coasters. And that's why I mentioned earlier that building a relationship is so critical. Just about every single deal I've ever done gets at some point in the deal, it gets to where you're relying on the relationship to get the deal done. Maybe something came up with the financial diligence and you have to go to the seller and say, hey, listen, we need to adjust the price because the valuation doesn't come out right. Or the bank ordered valuation doesn't match up and they can't lend you as much money. Or things are taking a long time and they're getting frustrated. Or the bank is asking for something for the fourth time and they're like, what's wrong with your lender? Why can't they get their facts straight? And that's where you need to make sure you've got a good relationship with the seller. But that's also the situation where, especially if a seller has options, and so that's the combination where we see if they look like they're kind of a little bit of a lawbreaker, might be a bit of a hothead, and then if they're not really retirement age, meaning their 40s, 50s, and they're selling because they want to, not because they have to, then that's a bit of a situation where I want to coach my client when I'm working with someone that's working with a seller like that, that you've got someone who, when backed against the wall, might just say, well, forget it, screw you and your deal team that can't get it closed, or your bank that can't get this loan finished. I'm just going to walk away. And sometimes we've got to know that might happen, and we got to prepare for it. So we need to approach things a certain way. There's all sorts of ways to get messages to the seller. So, for example, if we have a seller like that, we might say, okay, we got some bad news. Let's use the broker to break bad news to the seller instead of going directly to the seller, because sellers trust their brokers and brokers want to make their money. And if they don't make the sale, they don't earn a dollar. So we need to be strategic. So it's just intel to kind of use to shape our negotiations.
Have you noticed any other similar patterns other than this?
I've seen things like if they have multiple bankruptcies and tax liens. Again, we're not so worried about them being difficult to negotiate with, but that would trigger us to go, okay, we need to dig in deeper in reviewing their financials and getting reps and warranties about these particular types of things. We may need to do a tax diligence because they're sloppy. If they keep getting, I've done a deal, for example, where the person almost every year for 4 years running had a tax lien, and then it got paid off, a tax lien, and then it got paid off, a tax lien, and it got paid off, which indicated to us that they're not very good about paying their taxes. So we'd better keep an eye on things and make sure we're not paying their taxes after closing. So we needed to put in some protections there, make sure to review everything, and then have strong indemnifications. That's another example.
I mean, that completely makes sense. I mean, you already have given some strategies, but especially most of our buyers who are watching are basically looking to buy the first business or looking to buy the second or third business. So what are some of the ways, where they could do pre-diligence? I mean, you mentioned about ChatGPT and stuff, that's fine. But what are some of the ways they could do pre-diligence on the seller, without kind of costing them a bank, any free resources, like a specific site they could go to, and, anything specific they should be looking for?
Yeah, Open Corporates, for example, is somewhere where you can go and make sure you get information about the business, what the public records databases indicate is ownership, whether it's in good standing, and then you can take that information, go to the Secretary of State's website, do your own searches to make sure they're in good standing. If they are who they say they are, they're an actual company. If they say they're an LLC, Nebraska, and you go and check and there's no such name, well, then you got a problem and you need to get some follow-up information to make sure you're talking about the same company. You can check their DBA filings by just going to the state, and some states do it on the state level, some states do it on a county level. So you can check a lot of the things about their existence, that they're in good standing, they can actually sell the company. There are a number of they're not open source for background checks, but you can pay on a per use background check. So if you didn't want to hire a private investigator or a lawyer to do your background checks, you can use, I think there's sites like Checkmate where you can just pay a flat fee, or you can go to the state and just usually their state patrol or state police department will allow you to do a background check on people. Sometimes that gets back to the seller. So if you do it through official sources, sometimes that ends up getting back to them. So you got to be careful. Whereas lawyers and private investigators usually can use databases that just use public records based on date of birth, city location and just do a background check. So those are some of the resources people can use on their own. Um, there's others that I don't use because, of course, I use the ones that I pay for. But I know there's a number of them available for people who want to do it themselves.
Is there any like a recent story where like doing this pre-diligence, maybe like a quick Google search or like a quick search before doing the in-depth due diligence, like saved a buyer from end up doing a bad deal, probably with the wrong person?
I did have one where the buyer did their own diligence, found a news story on the seller, which was federal crimes. Obviously, that's a big issue. So that was a smoking gun. But I imagine you can easily find that type of a situation in other deals. So I actually don't have any other stories on that. Just because by the time I'm involved, they've already done their homework and it's past their rigors.
So one of the thing I think based on what you suggested was like first we do the pre-diligence, and then you have to kind of like deep and kind of like do a deeper due diligence to make sure everything is in order, and then kind of like focus on the structure and stuff to kind of like reduce the risk. So when it comes to like deeper due diligence, maybe figuring out the ownership of like if they own the business or the liens and stuff.
Actually, to be clear, once we need to do deeper due diligence, the LOI needs to be signed. Almost all sellers aren't going to open up their business much more until the LOI is signed. So you do the pre-diligence, you're like, okay, this is a good person to work with, good business to buy. Then you talk deal structure with the seller. And then usually once the LOI is signed, you would ask for a period of exclusivity where they're not going to be, and they're contractually bound not to talk to any other buyers, say 60, 90 days. I recommend 90. And then during that period is when you go, okay, now let's do the real diligence. And that's when you're under NDA and you're under LOI. That's when the sellers are going to give you quote unquote real numbers. They'll give you their real tax returns. They'll give you their real financials. And then when I work with the client and I'm doing legal due diligence, that's when I send them, I've got a very detailed seller questionnaire with questions about everything that I've ever wanted to know about a seller. We keep adding to that whenever we kind of have a point where we're like, wait, we should have asked that, and we'll add it to the questionnaire. So that's a continually evolving questionnaire. And then we have a legal due diligence list. It's probably about 40, 50 items that we want from most sellers. Everything from the documents that form the company. So we want to see articles of incorporation, certificate of formation, LLC operating agreement, bylaws, shareholder agreement, buy-sell agreements, anything that would restrict their ability to buy or sell the business. We want to see their cap table, and that's just basics on like how the entity was formed. So we want to see the contracts they use with the clients. We want a list of key clients. We want a list of key vendors, anybody who is important to run the business. And then we want any clients who are 10% or more of the business. So we know there's customer concentration we need to be worried about. And then we also run those people through our database to do a derogatory news search and litigation search so that we know, is there anything coming up that would affect one of their key clients, customers, or affect any of their important vendors. We also run credit. We do a lien check. We run background checks on all key people in the company. Then we want to see things like their contracts. We want to see their policies and procedures for their employees. If they've got subcontracts, we want to see those contracts, all the HR pieces of the company. I already mentioned policies and procedures, handbooks, whether they comply with Mandatory Leave Act, depending on the state, whether it's needed or not. We also help review insurance policies. We want to make sure that policies are sufficient. And then also, if a buyer is doing a stock purchase, meaning they're basically going to inherit all the insurance policies, we want to make sure that there's something that they're comfortable with. If it's an asset purchase, are they insurable? If they can't provide insurance policies, we might be concerned that they're not insurable. So those are most of the things we're looking at in the due diligence phase.
That's a lot. That's a lot. So I think based on everything you said, I think it's better just hire a good M&A lawyer than trying to go and do everything on our own. So the next question it's going to pop up in like a buyer's mind is like, when should we hire a lawyer? Is it like when we look at a deal or once the LOI is done? Like, what is because I have seen, most of the lawyers are like, they charge like per hour and stuff. So when we are looking at a deal, it's not even confirmed that, we are even going to buy it. We're just looking at it. So what is the best time for us, like as a buyer, to like introduce a M&A lawyer into the process?
So I get involved at two junctures. So since this is all I do, I'm 100% buy side M&A. So all I do is help buyers. I help at the stage where they're looking at a business and they're serious about it. So if they're just still looking at multiple businesses, there's not much I can do to help, and there's not much, like, I don't have the time to get involved in that stage. But if they're like, hey, I saw this one, I'm very interested in it now, how do I go about discussing deal structure and then putting an LOI together? It's often beneficial for an M&A lawyer to get involved at that stage, because we can advise on deal structure and risk mitigation and considerations, how to approach the seller, and then we can help draft the LOI so that it's complete, and it doesn't need to, for example, it meets SBA lending guidelines if it's going to be an SBA deal. So I get involved at that juncture frequently. And then if it's under LOI, I recommend that there be a pause in legal, so that legal kind of take pause until a lender looks at the deal and is comfortable lending on it, and then also that it passes financial. So most buyers will have some sort of financial due diligence done on the deal, and I highly recommend it, especially, again, if it's going to be a bank deal where you're going to be personally guaranteeing it. So they'll do a financial diligence, usually in the form of a quality of earnings report. So I recommend that the quality of earnings report come back, and either the final report come back, or at least a preliminary report showing that there's no issues in the financials. And at that point, since it's the deal's going to not die because you can't get lending, and not die because you can't get the pricing to meet up with what the expectations are, then that's the point where I recommend we get legal involved.
That's a pretty good answer. Like, I mean, you are an M&A lawyer, so based on everything I've heard, like you do a pretty good job on like whatever you do. So let's say
Thanks.
like some like one of our audience is looking at a different lawyers. Like, what are the things they should look for to make sure they are hiring like the right one? Any couple of 2-3 things they should
Oh yeah,
look for? Yeah.
absolutely. I've posted on this a few times, and actually have a checklist that I provide to people who subscribe to my newsletter. I think is an important topic. First of all, you want to make sure you've got a specialist. M&A is very specialized. It's almost like going in for surgery. You don't want a GP doing surgery on your eyes, for example, or any surgery. You want a surgeon. And so M&A is more like surgery than just general business questions. Very specific process, lots of risks for if not done right. So you want to make sure you've got a specialist, and this is not their first rodeo that they're learning on your deal. So find someone who actually specializes in M&A. I recommend that people do not just asking. You might ask the person, they're like, oh yeah, I do a lot of these. Check up on them. Go to their website and see what they say in their bio. It's surprising how many people will say, yeah, I'm an M&A specialist, and then you go to their bio and they talk about real estate and litigation and divorce and tax, and it's like, okay, no, you're not a real specialist because you just outed yourself in the bio on your website. So I recommend that they check up on them as well. And then I recommend that they only work with people who charge flat fees. You were talking about hourly fees. Yeah, I'm only flat fees. To my understanding, almost all specialists in this deal size being purchase prices between, say, $500,000 and 10 million, what they call the Main Street and lower mid-market range, are flat fee. If you've done it enough and this is what you do, you can charge a flat fee. The last thing you need when you're buying a business is to worry about what the charge is when you call your lawyer to ask a question, or at the end of the deal, is it going to blow you up? Is it not? I mean, you don't need to worry about that. So get a lawyer that charges flat fees. Get a lawyer who is cognizant of deal breakup. So a lot of these deals don't go through, even though you've started, even though you're under LOI, even though you've expended a bunch of money. So the days of lawyers in this field saying, I'm going to charge, let's just say $40,000, it's a larger deal, give it to me all now, those days should be over. Most lawyers who work in this field and understand searcher economics should provide some sort of tiered billing. So, X percent now, X percent later, and then an idea of what they're going to do to help the searcher if the deal breaks. And so there's usually a forgiveness of fees component or just a delayed billing so that the searcher doesn't like bite the whole bullet for all the lawyer's fees, whether it closes or not. There should be some shared risk. I also recommend that people ask around in the various communities that are available. Search Funder is a good place. X is great, except people don't talk as much. Search Funder, people will talk about their experiences with lawyers. And then I also recommend that they check out the reviews. So get on avvo.com, see if the lawyer's taken the time to set up their profile there. That's where they can do a lot to show that they're serious about their craft, that they put the time in. Check out the reviews, see what other people have said, see if they've got testimonials on their website. And then finally, I think a great way to check out a lawyer is see what content they have up there. I have a hard time believing someone's a specialist if they have zero content out there, if they're not on social media, if they've never written a blog post. How do we know you're a specialist? Kind of have to take your word for it. So that's also a great way to find out about somebody, do the research and see what they posted about.
Real quick, guys, each of these episodes represents over 30 hours of my personal work, not including my post-production team's time. I'm building this podcast to become the number one resource for business acquisitions, and the only way that's going to happen is through your feedback. So please drop a comment with a timestamp for the parts that you found valuable or not helpful. If you're on audio platforms, you can leave a review. This will help me understand what you like, what you don't like, so I can create exactly the content you want to see. Thanks for your support. Now back to the podcast. You mentioned that, especially when it comes to the pay structure, find someone, who's looking who's open to do flat fee and, delayed billing, who works with you rather than work against you. So what does the pricing looks like? I mean, if you could give me an example, let's say we have a buyer looking to buy, let's say $500,000 business, so the asking price is $500,000. What is the price, they could expect, and what does the structure would look like,
For $500,000 is harder to tell because a lot of people at that stage either do it themselves or, there's not a really well-developed structure. I can tell you from $1 million to 10, the deal, the fee to pay an attorney is typically somewhere around 1% of the purchase price. The reason I say it's harder to say at $500,000 is because there's no attorney out there who's going to do it for $5,000. That's just not going to happen. And then even at the 1 million range, you might run up against a $20,000 minimum or something like that. A lot of attorneys who deal with deals of any complexity would charge a minimum of about that.
I have had investors, I suggested them hey, hire a M&A lawyer, to make sure the legal stuff is taken care of. I mean, even I was ignorant. We used to hire a good accountants and stuff to make sure the financial is good, but we ignored the legal side of it. And we had issues with patent, when someone bought the business, we had so many other issues. So did you I'm pretty sure you come up with a lot of these, any good example of, where someone skipped the due diligence, told you hey, I think I could take care of this myself, and then got screwed over, for some of the legal reason, then came back, maybe to hire you to help them solve that issue or something like that?
I don't do that work, so I don't fix problems, but I do know of problems. So there's a lot of tax issues involved in deals, for example, and a lot of times people can run into unintended tax consequences if they don't do it right. So, for example, some purchase agreements are ambiguous as to whether it's an asset purchase or a stock purchase. There is a night and day difference in tax picture for the seller and for the buyer. So that's one example of you needed a lawyer to help you make sure this is done right. Sometimes the assets aren't properly identified and aren't properly transferred. So you buy it and you thought, hey, I got assets A through Z, and then you end up with assets A through N, and you're like, hey, how about the rest of them? And you look at the agreements, it's like, whoa, wait, you didn't actually buy those. And you talked about patents and trademarks. Oh, huge one there. If you didn't clearly specify that those were coming with the business, you could find out at the end of the day there was no obligation for the seller to sell those to you. And then if there's issues with there's a million issues, but those are some of the big ones. You could end up being responsible for the seller's taxes if there's no indemnification in there that clearly states that they need to indemnify you if you get hit with their taxes. So a lot of unintended consequences can come about if this deal isn't properly structured, and then the structure is properly reflected in the agreements. For things that you asked about, what comes up in diligence, I'd say about a third of the time when I do diligence on a deal, the seller entity is actually not in good standing. They're dissolved or they're suspended because they haven't paid their annual fees or they haven't filed an annual report. If you enter a transaction or agreement with someone whose entity is like dissolved, they actually couldn't sign the agreements legally. So you didn't have a binding contract, and you can't buy assets from an entity that's currently dissolved. So that could create a serious problem. I haven't seen what the aftermath of that might look like, but I can just say that even just a basic check and diligence, at least a third of the businesses that we deal with are not in compliance.
You mentioned about using a private investigator to kind of like do the background checks and stuff. I mean, as you mentioned, let's say someone is buying a business for $500,000 or less than $500,000. So, I mean, they might not be able to afford, like a pretty good M&A lawyer and stuff. Do you think is it less costlier to go and hire a, let's say, private investigator to do a background checks, or is it
Oh
better
yeah,
to hire an
I'm
M&A
sure it
lawyer?
is. And most of the time, if they can find one who will work with them, as I worked with a number of private investigators in the past and other career stages, and most of them will do a number of background checks on like a background check basis. They might charge $50, $100, or something like that. That's nothing compared to what you'd pay for full-on diligence by an M&A lawyer. So that's a good way to go.
Yeah, that's awesome. Like, is there any specific places, to find like a pretty good ones? Any?
I think it's a pretty easy thing to just check for a local background check investigator, or just do an online search. I don't know of any actually that I could recommend.
So now we're done with the pre-diligence. We are done with the due diligence. I think the one thing I want to go back to was basically the structuring the deals. I think if you properly structure the deal, I think that's going to reduce a lot of risk and make sure you don't get kind of like scam. I have had issues where the investors kind of like paid all cash to a specific specific seller all upfront, and then they didn't do a proper asset transfer, and then they went back to the seller to kind of like get the details of, let's say, the supplier contacts and stuff like that, and they kind of like ghosted them for a long time or come up with some random reasons. So is there any like specific type of structures you like common structures you use to make sure those things doesn't happen?
Sure. Yeah, good point. And so it starts with clear contracts and clear obligations. That's again where a good M&A lawyer will help you structure the M&A or your purchase agreement to make sure that the clear obligation is on the seller to transfer title to the assets. You'll have a bill of sale that backs that up for tangible assets, and then you have a intellectual property assignment agreement for anything that's intangible. And then on top of that, I always recommend for every single deal we have a transition services agreement, which is what does the seller need to do during the X number of months after closing to help transition the business. That's where we list out clear deliverables. And we'll say, you need to introduce us to all your vendors. You need to give us all the business records. You need to give us access to all your online accounts. If it's applicable, you need to give me access to your bank account. If it's a stock purchase, for example, you need to train me on all the business operations. You need to show me how to do X, Y, Z, depending on the business. It's customize it so that there is a clear contract that they sign saying, I'm going to do this. And then usually we want to make sure that not only is there a legal obligation, but there is a pot of money to back it up. So you mentioned something that I always cringe at, which is all cash closing, because exactly, a seller can just say, thanks for the check, I'm moving to the Bahamas, goodbye. And I've heard horror stories, and some of them are really, really bad horror stories. I've heard stories of people who ended up being in bankruptcy, 3 months after closing, 4 months after closing, because the seller would not help them transition a business that they could not operate. Therefore, they could not pay their few $1 million in SBA loans. And one of them actually ended up committing suicide because of that. So this is serious business, and a horrible ending, at least once, that it's kind of known in the SMB community. So we want to make sure that we clearly lay out in the contracts what the seller is obligated to do. We don't give all cash closings if we can at all avoid it. And the way we do that is we have the seller hold a note for a portion of the closing, so they have some incentive for the continued viability of the company. If you pay them all cash at a certain point, if they don't care about the company or they are a little less scrupulous, they could be like, okay, you can crash and burn for all I care because I've been paid. But if they've got some money that is yet to come to them, even if it's not a ton of money, psychologically, they're going to be more interested in helping you succeed. If the business is particularly dependent on their help in transitioning, we can also put money in escrow. So sometimes we'll do what's called a transition escrow, meaning we'll take a portion of the purchase price, put it in escrow, and we'll say, when you finish helping us transition all the assets and all the knowledge needed to operate this business, then the escrow will be released. But until you do that, we're just going to keep this money here with a third-party escrow. And sellers usually aren't super upset about that because they know that as soon as they fulfill the obligations in their transition services agreement, that money comes to them immediately. They don't have to wait. So it's not like a seller note that they get paid out over time. It's just money sitting there. They need to fulfill some obligations, and then bam, it's theirs.
The transition escrow was a good one. Haven't heard of it. So I mean, that is after they kind of bought the business, right?
Right. These all kick in after they buy the business, but these are all agreements that are part of the purchase agreement. So we always have the purchase agreement, and these are all exhibits that need to be signed at closing. So that's how we make sure everybody's on the same page about what exactly needs to be signed. We're not going to say, hey, we're going to sign an agreement that obligates you to do certain things, but we'll negotiate it later. We tell them exactly what the transition services agreement will say. We put it as an exhibit to the purchase agreement. So when we sign that, it's all a legally binding obligation.
I mean, you mentioned about, giving a seller note. Do you do earnouts as well, or maybe seller financing?
Earnouts are available as long as it's not an SBA deal. The SBA does not allow earnouts. And so the way we do earnouts in SBA deals is we call it a reverse earnout, meaning we'll have a seller note that might be larger than otherwise applicable. And if you don't meet the criteria for what would result in the payout in the earnout. So say the earnout says you need to meet 2024 earnings or higher, or and if you do, then we're going to pay you extra. Well, we just pay the extra in the seller note and say you need to meet 2024 earnings or higher, or we're going to reduce the seller note. So it's kind of like a reverse earnout. You can have a forgivable seller note. You just can't have an earnout.
If you think about the seller note, I mean, as you mentioned as well, what percentage, do you normally do it? Because for example, if it's a $10 million business, and if you're okay, mm-hmm. I'm going to give $500K seller note, I'm going to give you $9.5 million cash, it's not going to be that effective as when you are hey, we do $7 million cash or $3 million note or whatever that is. So what is the typical, a range you guys actually shoot for?
The typical, the straight down the middle would be 10%. That's very common. If the deal is riskier, we might go up to 15. 20 is the highest I've ever seen. I've only had one or two out of 100 plus that has been that high.
Done with the diligence, pre-diligence. Next we did with the deal structuring. And the next thing is basically I want to, probably your favorite, is the LOI and purchase agreement. I mean, one of the common maybe misconception, something I believed in was LOIs are non-binding. So it doesn't matter. You just take a template and you just do some changes and you just use that for all the business you buy. But I went through your post and I was oh, they are legally binding as well. Can you just tell more about that?
Yeah, so it's a common misconception that LOIs aren't binding anyway, so just put whatever you want in there and then just get it signed. For two reasons. Number one, even the non-binding provisions might as well be binding because that's what everybody agreed to and that's what everybody's going to use for the deal. So the seller is going to give it to their lawyer, the buyer is going to give it to their lawyer, and that's going to be the blueprint for the deal. So no one's ever gone to the seller and said, hey, we're going to change the price. It wasn't binding anyway, right? That's like a one-way ticket to a broken deal. Or we're going to change the size of the seller note. You knew that wasn't binding anyway, right? So whatever. It might as well be binding because as we talked about earlier, I recommend all the deal structure pieces go in there so everybody is agreed in principle. And I like to reference the psychological concept called, what do they call it? It's commitment and consistency. That's what it's called. So it's a psychological principle that when people say they will do something, they're more likely than not to follow through. So if the seller has already signed the LOI saying, I'm going to sell for this price and I'm going to sell for on these terms, they're probably going to come through with it, or they're going to follow through with it. So the non-binding provisions might as well be binding. And then there always are binding provisions in the LOI as well. At least a well-written LOI will have those. The binding provisions affect things such as a lot of sellers are asking for good faith deposits. So they might say, I will take this LOI as long as you put down $10,000. Well, we need a binding provision in the LOI that states how that $10,000 is going to be handled, what conditions will allow it to be refundable, and then what conditions would make it non-refundable. Otherwise, it's just, if everything was non-binding, then you just gave them $10,000 and they can kind of do whatever they want with it. Pretty dangerous. Another binding provision is exclusivity. So I mentioned earlier, we always make sure there's exclusivity in the LOI. Without an exclusivity provision that's binding, the seller can just say, yeah, I agreed in principle that I wouldn't go shop it to someone else, but since we're not getting along right now, I just found another buyer. Goodbye. And then you could be at a point where you've already expended $30, $40, $50,000 on your advisors, and then you're 4 months in the hole, and that's pretty painful for a searcher.
Yeah, that's the worst situation to be in.
So, I mean, absolutely.
Like, what's your thoughts on, I've seen these influencers talk about, just find like businesses and then just throw in LOIs, to show you're serious. And then somebody's going to say yes and just, go and get it at a really good price. I mean, what's your thoughts on that?
That's the worst approach ever. I think it's a great way to waste your time. A lot of sellers won't even give you the time of day if they don't feel like you put the time into an LOI and building a relationship with them, knowing what they want, customizing it to them. It's kind of like the same philosophy people have about applying for jobs. Like, I'll just send out a template resume and cover letter to everyone, and half the time, you got the wrong person in the 2-line, and they can tell this was a template and it's not very specific to the job. It's just like that. Like, you're not going to get much success there. I don't think you're going to get success with LOIs that way. And the worst part with the LOIs, we said earlier, as we discussed, if you don't have the deal structured down, then there's a good chance you're going to waste a lot of time negotiating. And then I've seen a lot of deals die on points that they negotiated 2-3 months after the LOI, when it should have been settled at the LOI stage. At least I would have helped settle it if I were involved in structuring it. Things such as networking capital, or AR, or things that are financially important, and really do affect how much money the seller gets at the end of the day, or stock versus asset purchase structure. There's no reason those should be negotiated well into the deal. Those should be settled at the LOI stage.
You mentioned about few provisions, you got to have in the LOI. Are there any other, let's say, clauses and stuff, you are like, hey, these are like a must, you got to have, doesn't matter who you hire, to draft your LOI?
I would recommend that you clearly identify the target. Sometimes people just use what's on the SIM, and believe it or not, I'd say at least 50% of the time the name on the SIM is not accurate. So I would use open corporates and make sure, they might say, sometimes they list it as their DBA. And you can't have to the extent a part of that is binding, having the correct business is super important. So you can't have a contract to buy a DBA. You have a contract to buy the entity. So make sure the entity is correct. I would make sure that the purchase price is clearly stated, and then clearly stated in what form they're coming to the seller. So $5 million total purchase price, $1 million seller note, $500,000 indemnity escrow, $3.5 million cash at close. It should say clearly where it's coming from so that the seller knows, because one of the things that they're concerned about is how likely are they going to be paid the full price. So they want to know where who's providing the money and how likely is it going to materialize? Are there contingencies? I would recommend letting the seller know if you're going to be obtaining financing, if you're going to have investors, because that's one of those things. Again, I wouldn't get under LOI and then later go, oh, by the way, buyer or seller, I've got investors coming on board, so it's going to take a while longer. They need to know that up front, because that can inject some uncertainty into it and some delays, and the sellers should know that. And if you've been open and honest with them up front, those delays aren't going to phase them. So I recommend all those things about sources of funding there. I recommend that you let the seller know what it is exactly you're buying, whether it's the stock or if it's an asset, what the deal structure looks like. If it's a stock deal, I always recommend that you let the seller know that if you want to get it treated as an asset deal. So there's a couple of different ways under IRS rules to treat a stock purchase as asset for purposes of a step up in basis. And that's a 336E, they call it, 338H, or doing what's called an F reorganization. So I would recommend you flag that for the seller so that doesn't surprise them later, because it really affects their tax picture and what they walk away from the deal with. So you want that clearly there. Any contingencies that you want the seller to know that you would want in place to, if the contingency doesn't go through, then you're not going to buy. Things such as financing or what they call material adverse effect. If something bad happens to the business, or if there's key employees that you need to keep, I recommend all those be in there. Or if the business needs to meet a certain earnings over a certain period of time, I always recommend that you let them know, this is what I'm looking at, and if it doesn't meet this, then I'm not going to buy it, even though we're under LOI. Say you're waiting for 2024 earnings to come in, you need it, and you want it to come in at a certain level or above, or you're not going to buy it, let them know. And then deal structure pieces such as networking capital, I think it always needs to be addressed, whether to let them know that you'll provide your own or you want them to provide it, what's going to happen to AR, what's going to happen to work in progress, who's going to handle warranty claims if it's a business that might have warranty claims. All of those things should be well addressed and fleshed out in the LOI.
Yeah, I mean, that completely makes sense. I mean, no one actually talks about when it comes to LOI. They're like, oh, just find a pretty good template, and that's fine. It's not binding. Don't worry about it. So, I mean, like once we're done with LOI, the next thing is the purchase agreement. I'm pretty sure unless, it's the deal structures and stuff has changed, like most of the stuff, take it from the LOI. And is there anything, specific to the LOI, the purchase agreement, where you say like, hey, these are the must, to protect yourself as a buyer? Anything like specific on the purchase agreement side?
Yeah, it gets pretty, we start getting down some pretty deep legal rabbit holes there. But, you want a lawyer who knows what they're doing to help you structure that. I'm going to get pretty arcane and pretty legal pretty quickly if we go down to too many of those. You want the proper identification of the structure. So there's a completely different structure, whether it's a stock purchase or an asset purchase. And so I've seen people straddle the middle with some DIY agreement that you can't even decipher. That's bad. You want to make sure if it's a stock or an asset purchase, even allocation of, the IRS requires you to allocate the purchase price between the 7 tax categories. You want to make sure that's agreed to. You want to clearly identify what you're buying, who needs to do what at closing, what the purchase price is going to be made of, and who needs to deliver what to who. You want really robust reps and warranties. That's where you're being protected as a buyer. But when I see some of these form agreements that brokers provide, and they have like 5 reps and warranties for the seller, wow, that's nothing. I mean, you're the one as a buyer paying millions of dollars to buy a business, and then you need the seller to represent to you many different things about the business, that it operates a certain way, that they don't have tax liabilities, that they've been properly filing their taxes, that they've got certain employees, that their employee plans are being operated legally. Basically, anything that they're saying to you in the due diligence process that they didn't write down in the purchase agreement as being true and that they're standing behind it, you've got no way to basically hold them to it. And if they said, hey, I've got, all my employees are properly employed and there's 10 of them and they don't want to put it in the agreement, and there ends up being 0 of them, or none of them are legally employable for whatever reasons, they don't exist, for example, or anything like that. If it's not in the agreement, it might as well not have been talked about, and you can't hold them to it. So the agreement is so critical. And I think people who are thinking, I'll just draft one myself, are playing with fire, especially if there's a lot of money at stake, and absolutely, especially if there's an SBA loan. Because people need to remember, if something goes bad, even if you think, oh, I can go sue the seller, it's like, in the meantime, you could have defaulted on your SBA loan already, and you personally guaranteed it. So you're going bankrupt.
Yeah.
No joke.
I mean, yeah, 100%. So I think you mentioned, I wanted to talk about that specific topic of reps and warranties, which you brought up. I mean, one of the things I've seen is like, even after they do all kind of due diligence and stuff, once they buy the business, there are things that shows up which the seller didn't tell about or talk about, and the buyer didn't find it. So most of the, like, especially the first time buyers have no idea about like what reps and warranties are, like about the insurance and those kind of that side of it. So can you give a little bit more on like what they are, like how they work, and like what you should have, the what do you call it, the purchase agreement? I mean, not in depth, but at least like a basic.
Sure. Yeah. So the typical agreement I've got is like 20 to 30, sometimes even more reps and warranties. These are things that the seller is saying about their business, and they're saying this is true. It's just like when you buy a house, most states will require the seller to sign a disclosure agreement. Same thing. When you're selling a house, you're saying, hey, I've never had a leak. All the walls are, rotten, like there's no rotting inside the house. There's no termite infestation. I've never had a fire. I bought this house when the water is well fed, or I've got city water. I've got these utilities. Those are all things that are important for a buyer of a house, so they know that it will fit their needs. Same thing, but even more expansive when you're buying a business. So the seller needs to tell you things such as, I properly formed this business. To my knowledge, it's authorized to do business in this state. I've got all the licenses needed for it, and here they are, so that you can make sure you got the licenses too. There's no pending litigation, and no one has told me they're going to sue me. These are the assets that are needed to operate the business. I'm not holding back on anything. I didn't leave anything out. The assets are in good condition. I've properly maintained records. I've got these many employees, and I'm listing them out for you. The business isn't about to fail because of some new change in the law. It goes on, and there's, like I said, usually high 20s, if not 30 some odd reps and warranties that are typical for any given transaction and purchase agreement that I draft. But those are to protect the buyer so that they know what they're buying. The seller is legally representing. So if they're misrepresenting, and so that, the second part is, what happens if they misrepresent? Well, then you get to sue them. And depending on whether it's a serious misrepresentation or a non-serious one, you can potentially get your entire purchase price back. If it's a serious one, for example, they said, hey, I've got title to all these assets. I can give it to you free and clear other than these liens, and we're going to clear the liens at closing. And then you find out that there's a secret creditor out there that had priority title to them, or they didn't really own it. Then you could sue the seller and get the purchase price back. So that's what the reps and warranties are there for.
So I have a follow-up on that. So especially when it comes to like online businesses, I'm more into online business as well, e-commerce, marketing agents, stuff like that.
Sure.
I mean, when they are buying internationally, let's say, they're in US, maybe buying a European-based business and stuff, like how do they go about this? Because, like you can't go to a different country and sue them. Would you suggest to just focus on deals within your country? Or like if they have done a deal, is it possible, to kind of like leverage this?
Yeah, I don't handle international deals. And the few that have come my way, I have reached out to my network to help get counsel in that country. You absolutely need counsel who can help you. If you're, for example, I had one that was like some European country, I can't even remember, but I ended up finding him someone who was an M&A lawyer there. Just happened to have some people in my contacts that had colleagues out there. That's critical, because I don't know how things get transferred. I don't even know how to, even begin to look things up. Too many unknowns. US based countries, absolutely no problem with online business. Some of it is harder to diligence. Like you can't like drive up to the business and make sure it exists, but you can do plenty of checks to make sure that the business is operating, has a credit score, and you rely on other entities. You make sure they've got a Dun and Bradstreet number, because all those things require verification on their part in order to get that. So they're not going to have a credit score unless they've gone through some pretty big steps to make sure that a bank has vetted them, and the credit reporting agencies have vetted them. They're not going to get a Dun and Bradstreet number until they go through Dun and Bradstreet's hoops. So you can use these third parties, and then I use Lexis for my background checks and my diligence services, and they've got a very broad and robust public records database that can give you background information on the company and whether they've collected all the data on the company and make sure they exist. So that's how you make sure to protect yourself with online business acquisitions in the US. But internationally, I think all bets are off. I don't recommend small time players do that. It's pretty hard to do. And then the hardest part is like, what if things go bad? Like, are you going to go travel out to Switzerland and sue a small business owner out there for misrepresenting to you? I don't think so. So I would leave international acquisitions to the big companies.
So I have seen this, I have seen like online, like something called as M&A insurance. I mean, if you have come across
Yes.
that, like how does
Yes.
that work? I mean, a little bit confused there. Like, how does it work, and what do you think would be the best deal size? Like, hey, if you are doing at this deal size, you should probably look into this.
Yeah, it's reps and warranties insurance is what you're thinking of. And that has always been available for M&A deals, but about until a year and a half ago, it was for deals, say 30, 40 million and up, because the premiums were like $100,000. So that new products have come out that have made it affordable for deals, say in the, once you start getting close to $5 million acquisition price, you might want to start thinking about that, especially if you're doing it as a stock purchase that does expose you to more of the seller's liabilities and gives you more exposure in general from a risk management standpoint. So the reps and warranties insurance, it depends on the policy and the carrier, and there's some industries that they won't touch. But generally what they will do is, we just talked about the reps and warranties that the seller is making to you. They're saying, hey, I've got title to all these, these are my employees, I've been in compliance with tax law, et cetera. If they misrepresented one of those, instead of suing the seller, you make a claim against the insurance policy, and the insurance policy would pay out. There are exceptions and disclaimers and blah 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 in there, but that's generally how it works.
Yeah, I mean, like if it goes well, I mean, I think that's a great asset to have, especially for the buyers, to protect themselves. Like I know
Sure.
you are still like looking at it. Like any specific companies you feel like, hey, I think these guys might be good. Maybe look into it.
Yeah, I don't have any companies I can talk about publicly. I usually make connections with a broker that I work with. So yeah, I can't talk publicly, otherwise it sounds like an endorsement, and I can't endorse anybody. So yeah, when I work with people though, when it comes to the right deal size, we might get in touch with my broker, and then we can discuss whether that makes sense. It's usually a one-time fee. And so, a lot of times buyer and seller split it. Seller can sleep better at night knowing they're not going to get sued. Buyer knows there's an insurance policy to cover reps and warranties, indemnity problems that they might encounter. And I think it's a win when you can get that in place.
As an investor, you can sleep better at night when you have an AI powered system working 24 into 7, sourcing the best investment opportunities for you. If you want to build your own AI powered deal sourcing system that shows opportunities on demand, watch this interview with Willem Westra, a deal sourcing wizard who has leveraged AI to send over 1 million emails to source 355 million worth of closed deals for over 100 plus PE firms, family offices, investment banks, and more. He breaks down exactly how to do that.